Welcome to the Dare to Know podcast. I'm your host, Fabian Corver. Today, we are joined by Andrei Marmor. Andrei Marmor is the Jacob Gould Schurman Professor of Philosophy and Law. His research interests span philosophy of law, moral, social, and political philosophy, and philosophy of language. His most recent books include Social Conventions, From Language to Law, Philosophy of Law, and The Language of Law. Today, we will talk and focus particularly on his book, Philosophy of Law. I hope you enjoy this episode. The Dare to Know podcast is now also available on iTunes and Spotify, so please check it out, and the links will be in the description below. Professor Marmor, welcome to the Dare to Know podcast.
Thank you. Pleasure to be here.
Yes, great. So today I would like to talk in particular about your book titled Philosophy of Law, which is part of the Princeton Foundation of Contemporary Philosophy series, which is a very great series. So in this book, you start off by saying the law is by and large a system of norms. Law's essential character is prescriptive. It purports to guide action, alter modes of behavior, constrain the practical deliberation of its subjects. Generally speaking, the law purports to give us reasons for action. So can you maybe elaborate kind of what is this essential character of law and how should we understand that?
Sure. That's actually the least controversial aspect of our discussions in legal philosophy. But there is, let me start with a terminological issue because curiously, social scientists and philosophers use the word norm and normative almost in opposite ways, opposite senses. So it confuses a lot of people. When social scientists or psychologists talk about a norm, they usually mean something that is generally the case. It's the standard. So when they say somebody is normative, they mean to say he or she behaves like everybody else. Okay? Philosophers use the word norm, not the way things are, but the way things ought to be, the way they should be. Okay? So when we say that there is a norm that's such, we talk about some kind of a demand, some kind of an expectation that something ought to be the case. So that's the sense in which we use normative. And the simple idea is that the laws are not there for theoretical purposes. It's not like, theory in physics or chemistry. They are there to solve practical problems. Laws are there to tell us what to do, okay, and what not to do. Now, this should not be taken overly simplistically, right? It doesn't mean that there's just one kind of norm. The law just tells you what to do, okay? Don't go out without a mask, okay? Many laws do that, right? Criminal law does that. Huge amount of regulation about industries and all sorts of aspects of our lives. The law just regulates. It tells you don't do this, do that. But that's only actually a fraction of the kind of norms the law comprises. There are many norms in the law that don't tell you what to do. They tell you if you want to do something, you don't have to. Then this is the way to do it in order for it to be legally recognized. Or norms that grant various agents the ability to introduce changes in the norms relating to others, right? So for example, if I make you an offer, a commercial offer, you can buy my car for £1,000, okay? Then you have the power to actually bind me contractually by saying, yes, okay, I agree, deal. You have created a contract. So you introduced a change in our normative situation. This is also norm, right? So the law has many, many kinds of norms, but what unites them is the idea that they purport to guide conduct, right? They are there to tell us how to do things, or what to do, what not to do, how to achieve certain goals, and so on and so forth. That's what we mean. And that's, if there's anything in philosophy of law that's agreed upon, that's pretty much it.
Okay, very interesting. So that's great to know indeed that that's kind of the general character, and it would also be very interesting to unpack this later in the conversation and relate it, for example, to indeed moral norms and how they then differ from legal norms. But moving on, you also discussed that there are kind of two major questions at play in the philosophy of law. And the first one is the question about legal validity. And the second one is the question about the concept of legal normativity. So this relates again to the norm question. So can you maybe run us through these two main questions? How should we think about them? And I guess that these are a bit more controversial where people don't agree.
Yes, that's where controversies are. Let me just qualify it and say that these are the two main traditional questions.
Mm-hmm.
A whole number of other questions pile on.
Mm-hmm.
And were developed more recently, and we can talk, I think we will talk about some of them later on. So don't understand me saying these are the only two big issues in philosophy of law these days. That's not true. Okay, but the two traditional questions are, indeed, as you say, about what is legal validity, or more general, what's legality? And the other is how to understand this normative aspect of law, this reason-giving aspect of law. So let me explain them briefly, okay? So here's one thing we know, right? We know that there are certain things which are legally required or permitted, etc., and things which are not, okay? You're not legally required to water your plants every week, but you are legally required certain places now to wear a mask if you go out in public, so on and so forth. So there is this idea that certain norms, certain expectations, certain rules have a legal character. They are part of the law somewhere, at some point, okay? Could be British law, or American law, or Indonesian. So the question is, what makes it the case that something is legal and the other thing is not? Okay. Well, you know, most people would say, oh, well, that's easy. Has somebody in authority enacted it? You know, was it enacted by the British Parliament or by some cabinet minister? And that's true about most cases. But still, we would want to know why the action of those people is legally significant. And if I have a great idea that everybody should do something, that's legally insignificant. So we need to figure out what are the conditions, what has to be true in the world for something to count as legally valid, as a requirement of the law. Mm-hmm. And that's where many, many debates in legal philosophy are focused, okay? Mm-hmm. And we can talk about various schools and various answers to this question, but that's the fundamental question. And that is probably the most fundamental question in philosophy. What makes things legal? Mm-hmm. Okay? What makes things count as law, mm-hmm, where they do? Now, the question about the normativity of law is a little bit more diffuse, and there are no clear schools of thought there, mm-hmm, right? It's not that there is this or that. Different philosophers have very different views about it. But here's the basic question. Suppose something is a legal obligation, no question about it. You see a no parking sign on the street, so you know that's a legal obligation not to park, okay? Now the question is, what kind of reason for action does it give you? Clearly wants to give you, it clearly tells you, dude, don't park here. Mm-hmm. If you do, you'll have to pay a fine. But what kind of reason for action does it give? So we know that it's kind of crazy to think that it's a moral reason. The law says don't do that. Then it means that you have a moral obligation not to do it. Why are we so certain about that? Well, because we know that there are a lot of silly laws, there are a lot of morally unacceptable laws, there are morally outrageous laws. So we know that a legal obligation doesn't just mean a moral obligation. Okay? But then there are difficult questions about how they might be related anyway. Okay? And here we need to kind of separate two issues. Okay? One which interests mostly political philosophers, moral philosophers, and one which interests legal philosophers. The political philosophy interest is in the question, do we have a general moral obligations to obey laws, assuming that we live in a decent legal regime? Mm-hmm. Okay? It's called the question of political obligation. Mm-hmm. It's the title. Okay? Do we have a moral obligation to obey laws? And how general this is. All laws, just because something is a law, we have a moral obligation. These kind of questions. So we put those aside. Okay? We say that's a moral political question. Okay? What we want to understand is the nature of legal normativity. Okay? What does the law purport to do? Okay? And how to explain that. And here's a very important feature of legal normativity that we don't find in morality, we don't find in many other contexts. And that's a feature that needs to be explained. When the law tells you to do something, don't park it, okay? Clearly the law assumes that there are good reasons not to park it. But the law is not there to remind us that we have reasons for action. The law tells you, do this because I say so, okay? That's what we need to explain. What's the rationale of that? How to explain that? How to take that, you know? How does it relate to moral and other kinds of reasons? But this is the crucial element, that when the law tells you to do something, it tells you to do it in part because it says so.
I see. Okay? And you also label that, I think, as the kind of authoritative nature of law, yeah. Right?
So one way to explain that, I think the best way to explain that is to understand that law is authority. And that's generally the nature of authorities. So, you know, maybe we can go into that later, but that's the question. A different. Now, let me just conclude this answer to just clarifying the issue here by saying that when philosophers try to explain this normativity of law, how to understand normativity of law, one question they ask themselves, is there anything unique to law besides this general feature that when the law says? And here we are kind of divided in all sorts of ways. Some people think that obviously the answer is yes, that the law is a very unique normative legal system and there has to be something unique about its normativity. And some of us think, no, it's actually very similar to other cases. It combines familiar ways of giving people reasons for action depending on circumstances. There's nothing really unique to legal normativity. I happen to share that. It doesn't come across very clearly in my book, more recent stuff, but I kind of share that view that there's actually nothing all that unique to the normativity of law. It's just a combination of things that are familiar from other contexts.
Very interesting, very interesting. So yeah, we'll unpack this also later in the call, but kind of going back kind of through the historical roots. So you discuss also three main schools of thought that have emerged in response to kind of the general questions that we've just been discussing related to the conditions of legal validity. So can you maybe go back a little bit in history and explain what are those schools of thought and how did they emerge or how did they respond to each other?
Okay, that's somewhat schematic, but here it is. So the oldest school of thought, perhaps, historically, that dates back to probably late medieval, especially Catholic theology and philosophy, probably heavily influenced by Islamic philosophy that's couple of centuries earlier. It's called natural law. Okay. So what is natural law? Obviously, it's controversial, and what I'm going to say now is not necessarily what my natural law colleagues would necessarily agree with, but here's the basic idea, the basic insight. It's a combination of two insights, okay? One which is not so controversial and one which is very controversial, so much so that it's not clear who holds that view anymore. The not controversial, the less controversial claim of natural law is that law inherently manifests or instantiates some good. Okay? The law is a kind of common good. Even bad law, even far from perfect, right? The laws are there and they achieve something that we value, something that's and there is a lot going for this view, right? The reasons for having law didn't just occur out of nothing. Many reasons. Those reasons respond to our needs, and they are there to make our lives better in certain ways. So clearly there's something inherently good about the law or having law. But here's the second controversial thesis. That's the one that's usually associated with traditional, especially late medieval natural law. It says, since law is inherently good, something that fails to be good, miserably fails to be good, like terribly fails to be good, cannot be law. It's not legal. Okay? So if something is profoundly immoral, then it fails to be law. It's not really legally valid. Okay? And people capture this by the famous dictum associated with St. Augustine, which says, lex injusta non est lex. Unjust law is not law. Okay? So that's a thesis that very few people actually are willing to endorse, simply because evidence to the contrary is abundant, right? You know, we are familiar with legal systems that are morally iniquitous. We are familiar with many, many laws that are clearly moral, and nobody doubts their legality. So the idea that there are bad laws, morally bad laws, is just difficult to deny.
I see.
I think that the first, less controversial aspect of natural law is a view that's actually held by many people, including those who reject all other aspects of natural law, like me.
I see.
So we can accept that. We can accept that there's something inherently good about the law. What is very difficult to accept, difficult to make sense of, is this idea that if a law is profoundly immoral, it just fails to be law.
I see.
No, it's just bad law. There are lots of bad laws. Okay?
I see.
So the second school of thought, and I'm not suggesting that it emerged as a response to traditional natural law, though that's kind of the way a lot of people teach it in, you know, introductory courses. That's probably historically inaccurate.
Okay.
But in the early decades of the 19th century, a school of thought emerged that's been called since legal positivism. The main figures who developed this theory of law are Jeremy Bentham and his follower, student, in a way, John Austin. It's confusing. There are two John Austins in philosophy. One is the legal philosopher from the 19th century, and one is the analytical philosopher from the 20th century. As far as I know, no relation, apart from interest in philosophy. So John Austin's articulation of legal positivism is the most consistent of the 19th century school of thought. So their idea is that the answer to the question, what makes things legal? What are the conditions of legality? Okay, can be given by pointing to the relevant social facts. In other words, morality, religion, things have nothing to do with it. Mm-hmm. It all depends on certain facts that happen in the world. What kind of facts? Well, according to Austin, there are facts about political sovereignty. Mm-hmm. The law necessarily derives from political sovereignty. It's the command of the sovereign. Facts about how we identify the political sovereign, who counts as a political sovereign, facts about what commands are, and so on and so forth. But these are all social facts, okay? Mm-hmm. They're facts that don't depend on what ought to be the case, mm-hmm. okay? And that's the general idea of legal positivism, right? That we can reduce, we can ground legality in facts about various things that happen mm-hmm. in the world. Okay? This legal positivist school of thought went through a very significant transformation in the first half of the 20th century. And there are two main protagonists to that transformation who agree on many things and disagree on some fundamental things. And they are Hans Kelsen and H.L.A. Hart, both writing about the same time and both developing a much more sophisticated version of legal positivism, rejecting many of Austin's specific ideas, but accepting the fundamental idea that legality can be based on social facts. It's a matter of social facts. Mm-hmm. Then later in the 20th century, around the 1970s, there is a great deal of pushback. And the pushback does not come in the form of trying to revive, medieval natural law or Catholic natural law. It comes in the form of trying to show that this reductive project, this idea that we can fully explain the idea of legality by pointing to the relevant social facts, is bound to fail. Why is it bound to fail? Because there are many cases where morality, partly at least, determine what counts as law. Okay? So, in other words, I'm not sure that this is helpful, but it's not a wrong way to put it. Mm-hmm. Traditional natural law thinks of morality as a threshold, as a kind of necessary condition for legality. If you fail morality, you fail to make law. Mm-hmm. The contemporary version of what we now call anti-positivism, to distinguish it from natural law, mm-hmm. doesn't buy that. They don't say that morality is a necessary condition, mm-hmm. but they say it's sometimes a sufficient condition. Mm-hmm. That something is morally required bears on the legality of this or that. Mm-hmm. Okay? So one way, it's one thing that kind of easily supports that view mm-hmm. is that anti-positivists often point to legal reasoning. They point to the way judges justify their decisions. Mm-hmm. They say, look, it's not infrequent that judges would say that something is or is not the law mm-hmm. based on principles of justice or morality and things like that. Mm-hmm. Okay? So you cannot say that legality is fully a matter of social facts. Mm-hmm. It's also a matter of moral truth. Mm-hmm. But it's true from a moral point of view. Mm-hmm. And that's the kind of contemporary anti-positivist school of thought.
And if I would rephrase it in my own words, and correct me please if I'm wrong, if you would say like some moral principles are built into the law, would that be too strong for the anti-positivist movement, or would that actually also kind of fit in if I would make that statement in such a way?
So it's tricky.
That's what I thought.
Because To make things simple, I'm a positivist.
Mm-hmm, mm-hmm.
I've defended legal positivism in some version for decades. Okay. So for me, the idea of built-in is good. I'm happy with that.
Mm-hmm.
I said, yeah, okay, judges rely on moral principles because they are entrenched in the law.
Mm-hmm.
Right? There is a custom, there is a practice of treating certain principles as part of the law.
Mm-hmm.
So that's fine because that's based on social facts. It's based on the behavior of judges.
Mm-hmm. I see. Yeah.
Okay?
Yeah.
So I'm fine with that.
Mm-hmm.
What anti-positivists want to say is that that's not the reason why those moral principles are part of the law. The
Mm-hmm.
reason is that they are moral principles.
Mm-hmm. Mm-hmm.
Okay? The reason is that they are true.
Mm-hmm.
Okay?
I see.
And when judges say this cannot be the law because it's profoundly immoral or something like that, or this is the law because it's required by this moral principle, they're not appealing to a custom. They're not appealing to something that's built in or entrenched.
Mm-hmm. Yeah.
They're saying because it's morally true that it's the law, right?
Yeah.
That's what the debate is about.
That's very helpful. Yeah, that's very, very interesting. And you already touched upon the topic of reduction. So maybe just to clarify what this exactly means for our audience. So you talk about reducing kind of social facts to facts of another type. But what does this mean? Like, how should we understand maybe this somewhat technical notion of reduction?
There are many. No, it's intuitive. It's very simple. Mm-hmm. Technically, there are a lot of problems there, but the intuitive idea is very simple. One thing, there are various kinds of explanations, right? All sorts of explanations. One very common type of explanation is explaining one thing in terms of another. Okay? And some of these are reductive. So what's a reduction? When we have a certain type of case of statements, certain types of propositions that we can identify as a type, okay? Say propositions about the mental aspects of our reality, okay? Everything that's true about the mental. And then there is another type of propositions we can also identify as a type, say everything physical, everything that's part of the fabric of the physical universe. Mm-hmm. So we can try to explain the mental by way of reducing it to the physical. Mm-hmm. That's a reductive explanation. Okay? So in philosophy of mind, for example, traditionally, again, it's a huge oversimplification, but traditionally there are two views. One view is there are two aspects to the universe, to the world, at least on our planet, the mental and the physical, and they are separate. And there's no way of explaining one in terms of the other. And then there is a view called sometimes monism, mm-hmm. or reduction view, which says, no. We should be able to explain all the mental phenomena, everything we experience as mental, mm-hmm. in terms of the physical reality. Mm-hmm. Okay? Should be by neuroscience, by what have you. And these kinds of explanations are extremely ambitious, right? I mean, we have not yet succeeded in explaining all the mental aspects of our reality in terms of the physical aspect, mm-hmm. right? And it's not clear that we ever will. It's debated. Because these kinds of theories that attempt to explain one type of phenomena in terms of a different type are very ambitious, mm-hmm. because they have to explain everything. Mm-hmm. Right? Suppose, let me give an example from the mental, physical. So certain aspects of the sensation of pain we can explain by neuroscience. We can say, look, this is what happens in the neurons of the brain. Yeah, great. So we know what causes pain. Okay, the but we still don't know how to explain the feeling of pain, right? That I feel it and you just know about it if I have a headache, okay? Or you have a headache and I can know about it, but I don't feel your headache. So how to explain that? We don't have an explanation of that yet.
Yeah.
So these are very ambitious projects, but the idea is trying to explain one type of phenomena, one aspect of the world in terms of reality. Going back to legal philosophy, it's less, I think it's much easier than the mental physical. What we're trying to do is explain the legal aspects of reality. So explain the idea of legality in terms of familiar types of social facts and facts about the world, like the people's conduct, actual overt behavior, regularity of behavior, their attitudes, beliefs, desires, etc., etc. That would be a reductive explanation. And I think that legal positivism is, by and large, with a few exceptions, in that business, right? We're trying to say legality is just a matter of people's patterns of conduct and attitudes they share about it, beliefs.
Very interesting. So, and kind of in your book, you also discuss kind of a theory of law that is anti-reductionist. So you already referred to him, Kelsen. So can you please explain his anti-reductionist kind of approach to law? And he specifically talks about the basic norm. So could you give us kind of a picture indeed, like what does a theory of law that is anti-reductionist look like?
Kelsen is one of the most interesting and peculiar, but also probably the most influential jurists to ever live, at least in the last few hundred years. There's lots and lots of interesting ideas, some of them obviously right, some of them obviously wrong, and some of them interesting, you know. So let me kind of start with the familiar, with the kind of very, very intuitive ideas, and then get to the answer to your question, why is it not reduction? Okay. So here's how Kelsen thinks. Okay. Take a city ordinance, no parking on Main Street. Okay. What makes it legal? Well, we know the answer. A bunch of people gathered in City Hall, talked about it, documents were written. At some point they had a vote, they raised their hands, voted for it, the mayor signed it. That's the city ordinance. Okay, what makes it legal? What's the difference between that and a bunch of my friends gathering at home and thinking, you know what, guys, it's really a bad idea to park on Main Street, let's make it the law. Okay, that would be a joke. So Kelsen's answer, very simple. There is a law, a higher legal norm that grants the city council and the mayor the authority to make these kinds of regulations. Okay, what's that? Let's suppose that it's a state act, an act enacted by the state legislature that defines the authority of municipalities. Okay, what makes that law? Well, we know the story. A bunch of people gathered in the state capitol building, talked, blah, 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 raised their hands, the governor signed it, and so on and so forth. What makes that legal? Why is that different from, you know, my friends doing the same? Well, again, there is a higher legal norm, let's say the state constitution, that grants the state legislature the authority to make these kinds of things. And you can see how the story continues, same way. So we get to something like the Constitution. Okay, what's that? highest legal norm in the US. It's the US Constitution. Okay? What makes the Constitution legally valid? Why that document and not, something else? So Kelsen says, here we need to stop. Okay? There isn't a higher legal norm, at least not in the US, about the, talking about the historically first constitution, that granted anyone the authority to make those kinds of legal enactments. So what makes the Constitution legally valid? And here Kelsen says, we just have to presuppose its legal validity. Okay? We just assume that it's legal valid. Okay? Who is we? Well, lawyers, people, anyone who takes American law seriously, anyone who regards American law as law, just needs to presuppose the legal validity of the American Constitution and then everything that follows from it. And the same is true about any other legal system. Okay? What makes this view positivist and what makes it anti-reductionist? It's kind of, and these two things don't sit easily together. They don't sit comfortably together. What makes it positivist is the recognition that legality is determined by actual actions and events happening in the world. Nothing to do with morality. People gather in a hall, raise their hand. Why does that have legal effect? Because there is a higher legal norm that grants them the power to do that. But it all depends on actual facts in the world. Okay? What makes it anti-reductionist is this idea of the presupposition, right? The idea that legality is something that we just have to presuppose. Now, answering your question, you mentioned the basic norm. So it's just a label for this presupposition. So the idea is that every legal system in place, like American law, British law, Roman law at the time, whatever, has this hierarchy, this ladder of norms authorizing the creation of other norms, but eventually it gets to a point of the fundamental authorizing norm of the system, right? What makes the American Constitution legally valid, the presupposition that it's legally valid, and that's the basic norm. So every legal system has a basic norm from which all the others derive in a kind of hierarchical structure. Now, Kelsen thought that it's not only the law that has basic norm. Every normative system has its basic norm, right? So if you are guided by a certain religious legal system, normative system, okay, then you have to presuppose the basic norm of that religion, that, X is God and God's commands are binding. Okay?
I see.
Yeah.
One quick question that I'm thinking about. So this basic norm, like, for example, when you say religion also has this basic norm, like what is kind of the content of the basic norm in a legal context then? Like, can we talk about kind of content, or is it just kind of the justification piece that can be kind of separated from actual content that we can attach to it, so to speak?
So here's where I think that Kelsen gets in trouble.
Okay.
Here's where you can see why this positivism on the one side, and he was very self-proclaimed positivist. I mean, it's not something we attribute to him. He saw himself as a pure legal positivist. And his anti-reductionism, his attempt to show that law, like morality, like religion, like all these normative systems, is autonomous, is kind of stands on its own, and it stands on its own because we just have to presuppose its basic norm. So this is why these two things don't sit together. Precisely in trying to answer your question, okay, but what is the content of what determines the content of the basic norm? How do we know that the basic norm in the US is the validity of the first historical constitution? How do we know that the basic norm in the UK is the fundamental principle of the sovereignty of parliament? Mm-hmm. And so on and so forth. And here Kelsen had to admit, in a way he was almost the first to admit, that it's just what lawyers believe in the UK, in the US, etc. It's just praxis, okay? And he gave a very good demonstration of that when he talks about how to think about revolutions, mm-hmm. Okay? So suppose we have a monarchy, traditional monarchy, someplace, country X, okay? And then a coup d'etat takes place and some military junta takes over and declares a republic. And they enact a new constitution, an anti-monarchical Republican constitution. And, you know, things go on for a while, a long while, and we have a kind of new legal order. Mm-hmm. Okay? So what Kelsen says, well, evidently, the basic norm changed here. The basic norm used to be that the monarch's commands or whatever determine the law. That's no longer the case. Now we have a Republican government and, I don't know, the parliament is sovereign. So we have a change in the basic law. What determines the change? This fact, the social fact, that that's the norm, the basic norm that people actually presuppose. Mm-hmm. Right? Mm-hmm. Yeah. So that makes it very reductionist, yeah, because it reduces legality to patterns of conduct and attitudes of people. Mm-hmm. I see. Okay? So I think Kelsen had a real trouble, real problem maintaining these two assumptions in his theory, mm-hmm. the reductionist one, the anti-reductionist one, the idea that legality stands on its own, on the one hand, on the other hand, these positivist convictions, mm-hmm. that what the legality is, what the basic norm is, depends on actual facts.
Mm-hmm. I see, yeah. That's very interesting. And kind of when we move on to the other main figure, so when we move on to Hart, so you discussed that he kind of responds a lot to the command theory of law, and then specifically, he's not satisfied with two components of that theory, namely that the law always has the form of a command, and secondly, that it necessarily originates from the political sovereign. So now can you kind of sketch what was Hart responding to, and what did he put forward himself that became very prominent?
So Hart has two targets. One that he makes evidently clear in his important book, The Concept of Law, 1961, and one that's almost hidden, but not less important, which is Kelsen.
Mm-hmm. I see.
So the self-identified target is Austin. Hart spends half of his book about dismantling Austin's construction. Says, law is not so closely tied to political sovereignty. We don't have a non-legal conception of sovereignty at all. The whole idea of sovereignty is itself a legal construction. It's not pre-legal, it's not illegal. So you can't reduce legality to political sovereignty because political sovereignty depends on laws. Law is not a command, as Austin thought. Law is not so closely tied to sanctions, to the use of force, as Austin. It kind of dismantles all the Austinian construction step by step, very convincingly in most cases. One thing that many of my colleagues don't realize, though, and I was at pains to show in various books and articles, is that what Hart dismantles, what Hart targets, are the specific building blocks of Austin's theory, not the theoretical ambition not the project. He shares Austin's project of a reductive explanation of legality. He just says Austin building blocks are the wrong blocks. We need different. We need social rules. We need social acceptance. We need all sorts of things, not what Austin provides.
Mm-hmm.
So the project is the same. The building blocks are different.
Mm-hmm.
Okay? Now, a lot of his theory reads very much like Kelsen. Okay? And they both share a very fundamental insight about legality. They both share the insight that we cannot explain legality without some normative background. We have to assume that there are certain norms in place, certain rules that determine what counts as legal material and what doesn't. Right? There has to be a norm determining that the US Constitution is the supreme law of the land, okay? Or that Parliament makes law in England, and so on and so forth. So there has to be some normative framework. For Kelsen, this normative framework boils down to the idea of the basic norm, which is just something we have to presuppose. Just assume it, okay? And you don't have to. You can be an anarchist. You can say, nothing is legal, okay? I refuse to accept the basic norm. That's fine, Kelsen says. You can be an anarchist. Nothing logically prevents you from that. But if you're not an anarchist, you presuppose the basic norm. Hart says, there's no need for this presupposition crap.
Mm-hmm.
All we need to do is observe society. There are social rules. And whatever social rules people follow is what determines law in that society. Mm-hmm. Okay? So he rejects this anti-reductionist kind of, some people think Kantian idea of presupposition. Mm-hmm. And he says, no, it's a matter of sociology. Mm-hmm. You know, you want to know what the law in England is, go to England, observe, you know, see what the fundamental rules determining legality are. Mm-hmm. So what Kelsen called the basic norm, Hart calls the rules of recognition. Mm-hmm. Okay? And it's not just relabeling the same idea. It's telling us that the basic norms, what Kelsen takes to be the basic norms, are actually just social rules. Mm-hmm. Okay?
Very interesting. And one discussion or debate that's also going on, where you mentioned as you kind of stand in the middle, is on the topic of force, how central force is as a function of law in our social lives. So could you maybe explain, like, of course, some people might think indeed law, this force element is crucial or central to it. And then there's others who might think indeed it's only a minimal part of law. So where do you stand on this issue of force?
I stand where I hate standing, in the middle. Nice. I don't like people in the middle, but in this case, kind of in the middle. Mm-hmm. So let me just say that this debate about how central force and coercion is to what the law is and what it does for us and how it functions in our lives and in society does not divide according to the positivist, anti-positivist school of thought. That's it. Mm-hmm. It really doesn't. Some positivists, Bentham, Austin, Kelsen, thought that the use of force is absolutely central, essential to what the law is. That's what the law does in society. It tries to monopolize the use of force. It tries to monopolize violence. Mm-hmm. Okay? And the idea of sanction, the idea of law using force coercively, is the distinguishing important aspect of law. Mm-hmm. Other legal positivists and non-positivists on both sides say, no, this is a huge exaggeration. Yes, of course, criminal law needs sanctions. Yes, of course, we have sanctions along the way here and there. But the law has many other functions that have nothing to do with sanction. Mm-hmm. Right? And I would say that because of the tremendous influence of H.L.A. Hart on contemporary philosophy of law and jurisprudence, most people side with Hart on that. And his student, my mentor, Joseph Raz, who also shares that view. I'll mention his argument in a second. Raz's argument. So the kind of the standard view tends more towards, let's not exaggerate how sanctions are important. They're important, but okay. So there are, I think, a couple of corrections or thoughts worth considering. One is that, and in fact, early legal positivism is to blame for that. 19th century legal positivism is to blame for that. People confuse law with state. And a lot of things that early legal positivists had to say about the law, they should have said about the modern state.
I see. So
there is some truth to the idea that Kelsen made famous and Austin made famous, that law, that this idea that there is something that tries to monopolize the use of force and violence in society. They thought it's the law. I think it's historically and intellectually much more accurate to think about it as the function of the state. When modern states emerged somewhere in the 16th century and later mostly, that's part of the idea that that the political sovereign, the state, tries to monopolize violence. But that's not an essential aspect of law. Okay? Laws existed long before, centuries, if not millennia, before the idea of a modern state, or any idea of a state emerged. And we should be careful not to confuse the two. Certain aspects are essential to what states are. They're not necessarily essential to what law is.
That's very interesting. One quick follow-up question. If I remember correctly, I think regarding kind of the use of force, even though if you say it's not a huge part of the functions of law, nonetheless, it is still one of the main challenges that has to be justified in some sense. I think Dworkin mentioned that one of the major challenges that have to be justified is still using this kind of collective force. Does that argument hold even when you say, no, sure, it's a small part, but nonetheless?
Okay, skip something.
Okay.
So the distinction between law and state is just kind of a footnote. It's just remember that. Let's get back to law. So that still leaves the question open. How central coercion is, the use of force, to what the law is and what it does. So to show that it's not very central, Joseph Raz, that I mentioned earlier, suggested the following little thought experiment, which kind of aims to prove Hart's point that Austin hugely exaggerated this use of force. So it says, look, let's imagine a world in which is exactly like ours. Okay, it's a twin Earth. The only difference is that people in that imaginary world don't need sanctions. Okay? You ask them to do something, they'll do it. Okay? They don't need to be threatened by force to induce them to do the right thing. Okay? And then let's try to think, what kind of social arrangements those, let's call them for simplicity's sake, the world of angels, okay? They're not angels in the sense that they are necessarily good people. They're just angels in the sense they don't need to be threatened. They don't need to be coerced. So what would they need that kind of looks like law in our world? Well, it turns out a great deal. They would need a whole bunch of norms coordinating their behavior. They also need to know which side of the road to drive, otherwise they'll have collisions. they would need some institution to resolve conflicts. You know, interpersonal conflicts are bound to arise and they need somebody to settle them. So they need courts. And so on and so forth. I mean, the list goes on and on. And then we see, well, it looks very much like law in our world. Okay? So the point of it is to show that even without the need to threaten, to use violence, coercion, we still need a lot of law, which means that a lot of what the law does in our lives has very little to do with force and coercion. Okay? And I think most of my colleagues are convinced by this argument. They kind of see the point of it. Not everybody, and you mentioned Dworkin. Dworkin is not convinced by it. And I think that there is a lot going for the Dworkinian view, for the original 19th century naive view that law has a lot to do with force. For the following reason, that well, it's a combination of reasons. I'll give you an example. Think about contracts. Okay? So the law doesn't tell you to sell your car. It doesn't expect you to do it in a way that's legally recognized as a contract. You're free to do whatever you want. The law doesn't care. But the law tells you, dude, if you want to have a legally binding contract, here are the conditions. You have to abide by that. Okay? And if you abide by those conditions, we will recognize your contract as legally valid contract. Okay. So you scratch your head and think, why should I care? Why would I care? I want to sell my car. You know, Joe is willing to buy it. Brings me some, you know, goats instead. So I take the goats and he can take the car. And what do I care if it's a legally binding contract? Well, it turns out that we care in case something goes wrong. Then we knock on the door of the courts and say, excuse me, please help. And what kind of help we are seeking? Well, we're seeking force, right? We're seeking coercion, right? And then the law says, okay, if your contract is legally valid, we'll provide you the service. We'll knock on the other guy's door, big stick, and you know, take his goat away because you gave him your car. Okay? So one of the main services that the law provides is coercion, even in cases where the law doesn't tell you what to do. So that's why I'm saying I'm standing in the middle, because I don't think that's the case about everything the law does. There is a lot that the law does in our contemporary world that really has not much to do with coercion, coming with the stick and taking away your goat. But a lot of it does. A lot of it does. And I think it's extremely difficult to imagine a legal system which kind of can operate without coercion.
I see. Yeah, that makes sense. That's very interesting.
Now, just one word about Dworkin, to be fair to him. He doesn't really care much about this descriptive issue, the question of how much of law is coercive. As far as I know, he never really expresses any particular view about that. He cares about the moral issue. He says, you know, whatever the answer to the stuff that Andrei was talking about earlier is, what I care about is what justifies coercion, okay? And he thinks that the way to construct the legal theory is around this moral issue, okay? Because he thinks that's the most urgent moral concern, how to justify the collective use of coercion, which is what, at least partly what the law does. Okay?
Very interesting. And when we focus a little bit on Dworkin a bit more, he also responded or criticized Hart's theory of law. And he talks also about legal principles. So instead of legal rules, we now also have legal principles, again, back into the picture. Can you just briefly kind of explain this response by him why he does so.
So that goes back to something we talked about a bit earlier about Hart's reductive project, Hart, Austin, the whole legal positivism bunch with the exception of Kelsen. Let's say, look, we can explain the idea of legality by way of reducing it, explaining it in terms of facts about social behavior and attitude. So Dworkin's argument here on the basis of legal principles is to block that, is to say, no, that's not going to work. Mm-hmm. Why is that not going to work? Because there are cases where legality is determined by what is morally right or wrong. Mm-hmm. Not about what people think that morality requires. That's still a social fact. Mm-hmm. But about what is actually morally right or wrong. Mm-hmm. I see, yeah. Now, how do we get there? So it took a while for Dworkin to actually work out the details of this idea, but they start with this notion of legal principles. Okay? So it says, look, yeah, Hart is right that there are lots of laws out there enacted by parliament and ministers and agencies and blah, blah. Rules, legal rules. They are enacted. They are valid, legally valid, because they are enacted in the proper way. Mm-hmm. Then there are these moral principles, you know. It's bad to torture someone for fun. That's just a moral principle. Doesn't depend on anything people think or do. But in between, legal rules on the one hand, moral principles on the other, there is an intermediary category, kind of mixed category of legal principles. Okay? And judges rely on those legal principles in determining what's legal. Okay? So his famous example, it's not sure it's a very good example, but it is a case in New York State, in the appellate court of New York State from roughly the turn of 20th century, called Riggs versus Palmer. So what happens there is that the guy murders his grandfather in order to inherit his estate. And he's caught for the murder, he's in jail, but he claims the inheritance. It's what Israelis call chutzpah. So, according to the law, I'm entitled to inherit, even if I'm in jail, even if I murdered my grandfather. Judges look at the relevant laws, and it seems, yeah, there's nothing here about not being entitled to inherit if you did something terrible to get there. So the court relies on the principle that the law should not allow people to profit from their own wrongs. And says, even though it's not in the books that this guy does not get to inherit his murdered grandfather's estate, it's a legal principle that we can use, that we cannot allow people to gain profit from their own wrongs. Mm-hmm. Okay? Now, at the first, and Dworkin claims it's a legal principle, it's not a rule, because there are many cases where the law does allow people to gain from their own wrongs. Mm-hmm. It's not a bright kind of rule, but it's a principle. It's partly moral. It derives from what is morally right. Mm-hmm. It's not enacted by anyone, and judges rely on it. So when Dworkin presented this idea in the late 1970s, there was still a great deal of mystery about where do these legal principles come from, mm-hmm. you know? And some people said, well, they come from the custom, the habit of judges to rely on them. So that's perfectly in line with Hart and other legal positivists. it was a bit unclear. But then later, Dworkin clarified what he means by it and kind of took his theory one step further. He said, look, when judges face a difficult case, something that's not determined evidently, clearly by the rules, they reason in a certain way. They try to figure out what is the best moral justification of a certain body of law.
Mm-hmm.
Okay? And whatever is the best moral justification, whatever from a moral point of view best justifies this domain, this area of law, is also part of the law. These are the legal principles. Okay? Well, if that is correct, legal positivism is clearly incorrect.
Mm-hmm. Yeah.
Because it means that what is morally right partly determines what is law, what is legally required.
Mm-hmm.
Okay? And that's what a great deal of the debate is about.
Mm-hmm. Very interesting. I have one more question related to Dworkin, and that's related to the issue of interpretation. So that was also very prominent in his theory. Can you maybe explain what is the role of interpretation, and how did Dworkin use kind of this evaluative aspect of interpretation to influence kind of his theory?
So Dworkin's ideas about legal principles and how judges reason, partly on the basis of their best moral judgment about legality, was stage one. In somewhere in the 1980s, Dworkin kind of took another big step, mostly a methodological step, okay? And in a way made his views more radical, more overreaching, more ambitious, more interesting. And it's all around this idea of interpretation. Okay. So Dworkin makes two big assumptions. He tries to justify them to some extent, but there are two big assumptions, parallel. One is that whenever we say something about the content of the law requires this or that, even the parking regulation, anything, that is a result of interpretation. Right? We engaged in some interpretative process and we reached the conclusion, don't park. Or you're not allowed to murder your grandpa and try to inherit. It's not going to work. Okay? These legal contents are always results of interpretation. Okay? That's assumption number one. Assumption number two, that's in a way unrelated, but as I said, kind of runs parallel, that whenever we do legal philosophy or legal theory, when we try to explain what the law is, we're also in the business of interpretation. Okay? So philosophy of law is interpretation of a certain phenomenon, a certain practice. Okay? Interpretation is central to both. Why does it matter? So here's the basic insight about interpretation, that interpretation is neither purely descriptive. When you say, my interpretation of Anna Karenina, that it's all about patriarchal society and how it oppresses women. We're not describing something. It comes with a whole bunch of evaluative judgments. But it's also not just evaluating. We're not talking about the way the world ought to be. We're talking about the book, about the novel, about Anna Karenina. So interpretation is always a combination of talking about something. It has an object, it has a text, as it were. But it always relies on some evaluative judgments. Okay? And I think Dworkin's right about that. I think he's absolutely right that what's unique to this form of reasoning or understanding or explanation that we call interpretation, hermeneutics, is that we have to rely on various evaluative judgments about what is good and bad. I mean, think about interpreting a novel. You can't even begin to engage in that without having some views about what makes novels good, what makes them bad. Okay. So saying, oh, well, this is very long, doesn't contribute to interpretation of a novel unless length is an issue. That's a matter of evaluative judgment. Okay, so now combine in both of these realms the two assumptions here, the 2 points. First, about the content of law, where it's kind of easy. So suppose it's true that every conclusion about what the law requires, every conclusion about what the law is based on an interpretative reasoning. Okay? Number one. Number two, every interpretative reasoning is based on evaluative judgments about what is good and bad. Conclusion is, every determination about the content of the law is based on judgments about what is good and bad. Ergo, legal positivism sucks. Wrong. Okay? That's the argument. Okay? Now, it takes a whole damn book to work out the argument, but that's the essential argument. And the same argument applies to what we do in legal philosophy. It says, look, legal philosophy is interpretation. Interpretation depends on the evaluative judgments about why we value things of this kind. So legal philosophy is moral political philosophy. Right? It's not purely descriptive. It relies on judgments about importance and values and so on and so forth. Okay. And this generated a huge amount of debate in both of these fields, okay? Both in terms of what is the law, okay? And what is it that we do in philosophy. Okay? So there are two ways to resist that, two ways to resist the Dworkinian conclusion. One way is to dispute his assumption that interpretation is necessarily valid. Right? I think that's the wrong way to go. I think he's right about that. I think there's very important insights about that. The other way, which is my way of resisting it, is saying not everything is interpretation. Okay? Not about what the law requires and not in legal philosophy. Both domains, right? That's an ongoing debate.
I see. Okay, that's very interesting. And probably also related to the topic of interpretation, I guess, is also, and that's what you discuss in the last part of your book, is how language and law kind of relate to each other or influence each other, and how language can maybe help elaborate on some issues in law. So you even say that the philosophy of language is actually central to an understanding of law. And I'm assuming this is connected to interpretation, but please correct me if that's not the case. But can you maybe just explain indeed, because I think you wrote a lot about this topic, kind of how language relates to law, and kind of maybe what are some areas where philosophy of language can still do a lot for law in the current issues that are there?
Sure. So philosophy of language and understanding of linguistic communication is obviously central to law because the law communicates in natural language. Yeah. Right? So, you know, if we want to understand what are the determinants of legal content, Parliament enacts a law in English, if it's the British Parliament, okay? In American, if it's the American. That text has some content. Okay, tells us something about what we ought to do or what we may not do and things like that. Okay, what precisely that content is partly a linguistic issue, right? It's partly a matter of how do we understand linguistic communication? So obviously understanding linguistic communication and various complications that come up in that area have a major role to play in understanding law, because law is communicated in natural language. So, for example, there's a huge interest and body of literature, legal and others, about what we call statutory interpretation. how to go about understanding statutes and what to do and what can we do when there are questions about it, which is what courts normally engage.
Mm-hmm.
So I think philosophy of language can help a lot in that.
Mm-hmm.
That's part of what I'm trying to do.
Mm-hmm.
But it also is related in some fundamental way to the issue of interpretation and the scope of interpretation and Dworkin's theory.
Mm-hmm. Yeah.
So I said a big assumption in Dworkin's interpretative critique of legal positivism
mm-hmm.
is this idea that every understanding of the law is interpretation.
Mm-hmm.
That every conclusion about what the law requires is a result of some interpretation of it. But since law is talking to us in ordinary natural language, in English or French or Italian, it assumes that in ordinary communication, all our understanding of language, of linguistic communication, is interpreted the same way we interpret a novel or a work of art. And that strikes me as crazy.
That's it.
That I think is a profound misunderstanding of how language works.
Mm-hmm.
Just put it almost as a slogan, but trust me, there is a lot behind that, like 2 or 3 books. Interpretation is the exception to the standard understanding of linguistic communication. It's not the standard. It's not that when you say something, I put, so let's see how best to interpret what you said. No, first I understand what you said, and then there might be things I don't quite understand. That's where interpretation comes in.
I see, yeah.
And that's exactly the point that Dworkin denies. Right?
Mm-hmm.
He wants to say that everything is a matter of interpretation.
Mm-hmm.
There's no way of understanding without interpretation. Interpretation always mediates between an utterance, a statement, and like grasping its content.
I see. Very interesting. Well, Professor Marmor, this has been a very interesting conversation. I really enjoyed it. So thank you so much for being on the podcast. Do you have any parting words to the audience?
No, I enjoyed it too. Have fun.
Okay, great. Thank you so much.
Thank you.